activity. It's limited to recreational activity. There's not a single case that I can find or that Mercer has cited where any defendant has had to go past even a summary judgment when they've not charged admission and they've not had commercial activity. The best case to support.
But we have said that that's a test. So let me ask, if you go on even state parks, they may have an area that says this area maintained by some local organization. That local organization is trying to get goodwill, right? And so you're allowing them on for them to get goodwill, and you want to get goodwill out of that as well. Or, I mean, have you gone to a Little League game on a park in any city?
For several years, Your Honor.
There are all kinds of vendor signs, those vendor and sponsors to defray. So if you don't charge anyone, is that commercial activity? That you're allowing all those sponsors and vendors to put up their signs? They're trying to promote their own goodwill. They pay you actually to put up their signs. What happens?
Your Honor, I think there's a bright line application of the test currently.
Okay, what's the bright line? I just asked you. Little League Park with lots of sponsor signs.
I think that's commercial activity.
Okay.
I think under the statute, you're allowing commercial activity, and so that's not a recreational.
Do the words commercial activity appear in the statute?
Your Honor, the words recreational purpose appear in the statute, and the converse of that is commercial purpose.
So let me try this one, slightly different than Justice Namias's. I'm a public library, public land. I invite the entire public for a bird watching activity on a Saturday. People come, there's no charge. A food truck comes and parks itself outside of the library, didn't invite them, but they're there and they're selling food. Is that commercial activity?
Your Honor, that's why the balancing test works, because there are going to be so many case-specific factual situations that a judge would look at the facts and the evidence and decide.
But a judge didn't look at the facts and the evidence here, did they? When we're talking about workability, it sounds like under this scenario, it would go to the jury for a determination.
Your Honor, absolutely the judge looked at the facts here. Judge Hanson conducted an oral argument. He considered the evidence in the record, and here the evidence was clear that there is a plethora of commercial activity. We're not talking about a food truck that pulled up. In this case, and I know the court wants to consider stare decisis and whether this
What's the bright line? You said it was a bright line answer. So what's the bright line answer to Justice Warren? One food truck uninvited pulls up. Yes or no? Immunity or not?
I think it depends on whether the landowner invited and allowed the food truck to pull up. I think
they didn't invite him. But they allow him. In fact, so.
Well, then, Your Honor, I think under this court's balancing test, the judge has to make the determination whether that's sufficient evidence to create conflicting.
It's a bright line test. What is the bright line? A bright line test means I give you facts, you give me an answer. There's no balancing, there's no weighing, there's a bright line.
Well, the judge makes the determination if the factual evidence is in conflict. And so that, I think it would depend on if the owner allowed or invited the commercial activity.
They allow it.
Allowed it, but didn't kick them out.
Then I think it's a jury question.
Didn't invite them, but didn't kick them out.
Can we move on to the question of reliance? Because when we're talking about a statute that governs liability and immunity, that is not a contract or property kind of issue in the sense that we've usually talked about reliance interests. But it is this sort of thing that many landowners will use to govern their affairs. If I'm a landowner trying to decide whether to open my property to members of the public free of charge, I want to understand how the RPA applies to govern my affairs. And it seems to me that there's some reliance interest arising from that of the sort that we ought to consider in the stare decisis context. Can you talk about that?
Your Honor, I think any landowner here that consulted with an attorney and had them look at the RPA precedent would be advised that you are immune from liability if you don't charge admission and you don't have commercial activity. Because let's think about the purpose of the Recreational Property Act. I mean, the ideal situation to me is a farmer opens his land for a dove shoot, allows some boys to come and hunt, there's no admission charge, and there's no commercial activity. The only place this gets murky is where the defendants try and expand the immunity that the statute grants. And so you
Which of our
got,
cases clearly would have given it the advice that you could have no commercial activity whatsoever, whether it's invited or not?
well, it would be the ACOG line of cases and Hawthorne, because those cases,
Do those cases flatly prohibit commercial activity, or are those questions that go to a jury?
no, Your Honor, those cases say that you are going to assume the risk of going to a jury if you allow commercial activity.
Any
How's that-
commercial activity.
Any commercial activity, sure, and I'll concede that.
So again, if I put one sign up in my state park that says this gazebo built by the Boy Scouts, and the Boy Scouts want people to join the Boy Scouts, I've assumed the risk that that's maybe a jury question.
Obviously, on the fringes, there are going to be tough cases, but here, if you look at the text of the statute, you can't charge an admission fee, and the property must be being used for a recreational purpose.
What's your best case that says an indirect? Almost all the cases had some direct profit for the landowner. The ACOG cases, the vendors were paying to be in Centennial Olympic Park, and there was lots of other commercial activity that was directly benefiting. What's your best case for something where it's just kind of other people making money, you're letting other people in for them to make money, or I'm just looking for some goodwill?
Well, Your Honor, I think it's important to note this case does not rely simply on indirect financial benefit to Mercer. Mercer got direct cash pecuniary remuneration to help offset the cost of this event. So this is not a completely indirect financial benefit situation here.
Counselor, you keep referring repeatedly to the no charge for admission and for a recreational purpose, but it sounds like you're adding exclusively recreational purpose. What basis in the language of the statute do you point to say that the purpose must be exclusively recreational? Because I don't see any indication. It just says for recreational purposes.
Your Honor, that's a very good point, and I think that explains this court's grappling with that issue in ACOG and in Hawthorne, because as I mentioned, when it's a clear-cut case, farmer opening his land for a dove shoot, no commercial activity, no admissions fee, I think everyone agrees that's immunity. It doesn't get past summary judgment. The case doesn't get filed. Where it gets murky is where defendants start trying to expand the immunity, and they claim immunity for what is clearly a commercial event or an event.
There's only one commercial transaction contemplated in the entirety of the language of the statute, and that's an admission fee, right? I mean, there's no anywhere else. I understand we've talked about whether that the language commercial transaction appears, but that's the only commercial exchange contemplated anywhere within the statute. Would you agree?
That's the only place the statute talks about a direct charge.
Okay, and so, well, I mean, direct or indirect, right? I mean, it doesn't reference an indirect charge, does it?
That's correct.
Okay, so there's no other commercial transaction, and the language says if you don't charge admission and and there is a recreational purpose, it doesn't say exclusively recreational, it just says there is a recreational purpose, then you are immune. I mean, isn't that plain? I mean, going back to the bright line question, that's the bright line that's in the statute, right?
That's correct.
Okay, so why would we look to other commercial transactions not contemplated by the Act?
Well, I think a very important point to keep in mind is that this statute is a derogation of common law. It is taking away potential liability for a wrongful death claim.
That just means, I mean, you acknowledge that the text of a statute can actually derogate from the common law.
Absolutely, and that's...
So Justice Bethel asked you a question saying this is what the text looks like. We don't warp the text because we just don't want it to derogate from the common law, right?
I think a plain reading of this statute, Justice Namias, and when you look at the definition of recreational purposes...
All of those are from the perspective of the user. Not a single one is from the perspective of the owner.
Think about this, though. All those talk about a landowner passively opening up his land to allow the public at large to come in. None of those involve what we have here, which is a commercial event that the landowner sponsored. That's different than passively opening your land.
Why is that a commercial event? It was a free concert.
It was a commercial.
You allowed certain people to come on to serve the people coming.
Your Honor, it was
which is better for everyone than making them line up their food trucks along the street right outside your property.
This was clearly a commercial event in that it had corporate sponsorship, it had Bud Light tents, they were selling liquor for profit, they were doing it as an economic...
You say they, but none of the theys are the property owner, right?
The property owner here was Mercer for purposes of premises liability, and Mercer
What did they
received
do?
direct financial benefit in the form of corporate sponsorships that they sold to offset the cost of the event. Moreover, the whole purpose they were doing this event is because it was a brand promotional exercise and an economic development exercise. That's not nefarious, but you don't get immunity for it.
Thank you.
Thank you, Mr. Chief Justice. Unless the court has any specific questions, I don't have any rebuttal argument in my remaining 13 seconds.
Thank you, sir.
Thank you.
Thank you, counsel.